Hey, everybody. Welcome to another episode of Exponential Wealth. I'm your host, Aaron Moore. Today, we have a very special guest, Stefani Coggins, estate planning attorney. Welcome, Stefani.
Thank you, Aaron. Happy to be here.
Excellent. Listen, most people think that having an estate plan is for wealthy folks. You either have a trust fund, you have massive amounts of wealth. Why else would you need an estate plan? Big reason that we want to discuss that today is this is not for the ultra wealthy only. This is for a lot of different folks. We're going to dive into this. I think our listeners are going to have a real sense of why they need to take action to speak with an estate planning attorney today. We talked a little bit about some statistics, right? And I think it's only 32% of Americans have a will. That's scary, right? To think that so few people have. What are the things that people need to know first and foremost? And why do we need to take action today, Stefani?
Absolutely. It is a little scary that only 30%, maybe a little bit more of Americans have an estate plan. And I guess let's start with a discussion about what is estate planning. So estate planning is essentially the process of figuring out what happens to an individual and their things during two periods of time, either during incapacity, so you're alive but not well, or after death. Essentially, you're preparing documents that identify particular people you trust to help you during these times. And you're also identifying the manner in which actions are going to be taken during incapacity for you or for your loved ones after you're gone. And who needs an estate plan? Pretty much everyone needs an estate plan once you're over the age of 18 years old. What type of planning and how comprehensive that needs to be really depends on several factors, including whether you own real estate, if you have minor children, if you have a blended family where there are beneficiaries with special needs or disability issues, if you own a business, the list goes on. But essentially, once you're over 18, once you're a legal adult, everyone should have some form of a plan in place.
Stefani, I was 40 years old or over. Disclaimer, everybody, before I had an estate plan. When I hear that everyone over the age of 18 should have one, I think that's a shocking statistic. Let's go a little bit deeper, right? So you talked about a lot of different cases where folks need. And actually, a lot of clients that we work with currently are in the situation that you're describing, right? They have children, they own real estate, they have an interest in a business, whether their own or a family business, like you said. So what's next, right? So great, I need these. Why do I need these things? Like what happens if I don't have one?
Exactly. If you don't have an estate plan in California in place when you become incapacitated or after you've passed away, essentially California is going to get in there and make decisions for you. The court is going to appoint people to manage your estate and or advocate for your medical decisions. If you die without an estate plan in place, essentially California is going to give you one of the state's creation. It's called the law of intestacy, and it's California's best guess as to how you would want your estate divided in the event of your death. And all of this goes through probate court. It's the court's supervised process of making decisions for your estate. It's really the court appointing someone with the authority, reviewing all their decisions, reviewing if everything is what the court thinks is in your best interest. Now, probate is yeah, go ahead.
Keep saying the court this, the court that. I mean, so if you don't have a trust, do you have if you're the beneficiary or the child or a spouse of someone without a trust, literally the state of California in a courtroom is going to determine your future?
Yes, under the court's guidelines and under provisions that have been previously created. So if you're a family member and you're concerned about your loved one who's under a court supervised conservatorship, so that's they're alive but not well, there's really no recourse. Go ahead.
Or Britney Spears, who just
we don't talk about the Britney case. It's really sad, and it really gives conservatorships a bad name. There are some times when they are good, but essentially, if you're a family member, the only recourse, if you're concerned about what's going on, is to go into court and tell the judge. And there's no getting around those hearings and the cost of those hearings. If you're a beneficiary to an estate of someone who's passed away without an estate plan or with a will-based plan, your only recourse to kind of argue your side of things and your opinion is to go into court and explain to the judge and the other parties why you believe what you do and what should be done, and hope the court is on your side and case law is on your side. But there's no guarantee.
Right. And my understanding is that if you're going through a probate petition through the courts, that is public record, that your life, the books, everything about you and your family is now open to anyone who wants to know about it and go after it, potentially.
Yes. So you bring up a great point. We want to stay out of court for three main reasons. Public is the first reason. Anything that gets filed with the court is public record. And as you can imagine, that used to require going down to the court to search through records, but now it's as easy as logging in online and searching through all the documents. So you have no privacy in the probate court system. And another big reason we want to avoid probate court as much as possible is it's time consuming. It's governed by the court calendar. So if the court's case is backed up, if the court's calendar is backed up, your case is backed up. And there's no getting around that. I mean, in some counties right now, I'm waiting 4 to 6 months just to get a hearing in front of the judge to get someone appointed as the executor. Which means in order for them to get money at the end of the day, it's going to be well over a year and a half, sometimes 2 years for that to take place. So
Stephanie, I can imagine that if you own a home, right, or you're going to inherit a home, your parents died, there's siblings, there's no trust in place, property taxes, mortgage, upkeep. If you can't access and don't have access to the funds of the family, then that's going to be coming all out of pocket. Like you said, 4 to 6 months delay until you can actually take action on that home. That sounds devastating.
It's really rough for the family members, and it's really hard. You gotta find those funds somewhere, right? You've got to be able to keep paying for the mortgage and the maintenance and upkeep until either you receive the property or you sell it. If you're waiting 6 months for a hearing date just to get in charge to be able to list and sell the property, that's a huge burden on the family.
And I can imagine it's even more burdensome if there are children involved, right?
Exactly. Yeah. If we're talking about guardianship and we're talking about helping the kids keep going to school and tuition and housing, that's definitely not a situation you want to be in if you can avoid it.
Right. Yeah, I think that's one of the most challenging topics that you and I both in our respective professions talk about is planning for the unexpected and really the unspeakable. And it's really our job to bring these items to attention to our clients so that they have a plan in place. I can't imagine. You're already going through tragedy, right? Imagine you're a young child, or even just up to 18, you're in high school. What if you're in the last senior year of high school? You're 17 years old, your parents die, and all of a sudden, what happens to you? And if there's no plan in place, I could just imagine tragedy on top of the tragedy that's already befallen you.
Exactly. It's definitely something we can avoid it. So let's avoid it.
Stefani, I want to get on to our next point. You said something that might have people confused. It had me confused before I started doing this profession and working with you, and you really educating me on these things, and which is the whole point of having you on today. You mentioned if a family has a will, but not a trust. So I think that there's some confusion around what goes into an estate plan or a trust or a will. How do all these pieces fit together? Could you break that down for us, please?
Most certainly. I'm happy to do that. So let's go through what are the different parts and pieces of an estate plan when you're talking about the documents that are going to get created to help you during incapacity or after death. So I'm going to start with the trust. If you have a trust-based estate plan, then the trust is the centerpiece. And it's essentially a contract in place immediately upon signing that has a bunch of if-then statements. If this happens, then do this. And those statements outline your wishes for yourself if you're incapacitated or for your loved ones after you're gone. Because it's a contract, it's effective immediately, and it allows your successor trustees, who are the next people in charge, to quickly step in to act without any court order needed. So the trust keeps you out of a probate process so long as all the other T's are crossed and I's are dotted. And this means properly funding your trust and ensuring your successor trustees are in place and ready to go if needed to step in and take control or distribute assets. So next you have a pour-over will, or a last will and testament. So often you hear of the will as being the last will and testament, in which case it's very similar to a trust in that it outlines your wishes in the event of your death. However, a will-based estate plan actually requires a court probate process to officially place someone in charge of the estate. So you lose the benefits of a trust-based plan, which is privacy, speediness, and trust-based plans relate to cost savings. You're not paying court costs, court fees, and it's a different fee structure for trust administration.
Right. And you're avoiding, like you said earlier, the 4 to 6 month potential delay in trying to get a hearing in front of a judge to appoint the powers that you were mentioning that are outlined in that last will.
Exactly. You basically have your agents get a new document, new certification and trust in place that lets them start acting immediately. So it keeps you out of the probate system. Now, a trust-based plan will also almost always have what's called a pour-over will accompanying it. So for a trust to be effective on assets, the assets actually need to be funded or retitled to the trust. If something gets left out of the trust or forgotten, the pour-over will is there as the safety net to get it back into the trust without a full probate process. And additionally, and probably most importantly for people with minor children, the will is where we nominate or name our guardians for minor children, as that's the one thing we cannot take out of court supervision. So that's why a trust-based plan will also often have a pour-over will accompanying it.
Right. A lot of the times when I meet with clients, Stefani, and I ask them, hey, do you have an estate plan? Have you gone through a comprehensive estate planning process? And they go, oh, yeah. And they bring in this old, pre-COVID when they'd come into the office. Now they show me through the Zoom camera. It's the document this big, and they blow on it and dust flies everywhere. They haven't cracked this thing in 10, 20 years. That just, so even if they have one, right? So I think that your point, I can't imagine that life hasn't changed for them in the last 10 or 20 years. And you're saying this pour-over will captures all those things, either possessions or changes in family that have happened after the original trust has been published.
Yes. So the pour-over will really, truly is your safety net. The biggest time I see it being used is, let's say you have this beautiful home, you've refinanced it. Mortgage companies don't like dealing with trusts. It's just not their preference. They like individuals. So often they'll deed the property out to the individual for the refi process. And sometimes they forget to title it back in. If that's the case, your pour-over will is there to capture it. So again, we don't have to go through a full probate.
Stefani, I want to just stop right there. Listeners, did you hear what Stefani just said? If interest rates have been low, now they're creeping back up. I don't know how many people, a lot, have done refinances, cash out refinance. Luckily, no one I know has done a reverse mortgage. Those things, what you just said, will take your home, which is big reason of why you have an estate plan to put the house in there. They take it out. And then if you don't put it back in the trust, then if you don't do that, then the house is in jeopardy of losing all the benefits and instructions that you went through the process of creating in the first place. So if you have done a refinance and have a trust, this is call to action, number one.
Thank you, Aaron. That is super important for everyone out there, most certainly.
Yeah. Okay. So there were a lot of.
So let's get back into the documents.
Please. Okay? Yeah.
Because there's a couple more that definitely want to talk about. That's a part of a comprehensive estate plan. So we talked about the trust. We talked about the will. There's also a financial power of attorney involved. And that's a document that identifies your trusted agents to take legal or financial related actions on your behalf in the event you're incapacitated. So this is for anything that's outside the trust. So think of someone needing to file a tax return on your behalf or cancel credit cards, file a change of address with the post office. These are all non-trust related matters. So the financial power of attorney allows your agents to be able to legally take action on those matters as well. We also have a medical healthcare directive, also known as a power of attorney for medical care, advanced healthcare directive. It's got many names, but that's the document that identifies your trusted agents to advocate on your behalf in the event you're not able to do so in a medical setting. So think of signing surgical consent forms, placement in a medical care facility. Someone needs to be authorized to make those decisions, and that's your healthcare agent. Also, really important, the directive is where you identify your wishes regarding life-sustaining support or organ donation. So if you have preferences regarding being kept alive or just being kept comfortable, you get to identify those wishes in advance on your healthcare directive. You also get to identify if you have any specific wishes regarding organ donation, whether you want to donate or not, and how you want to donate and for what purposes. You get to make those decisions in advance on your directive, and that gives good information to your agents so they can fully advocate for what you want in those circumstances. And lastly, to go along with the healthcare directive, we have a HIPAA, and that's an authorization for release of protected medical information. And that allows your agents to access your medical records so they can make informed decisions on your behalf. And this is also a document where you can identify other people you want to be informed of your medical care and status, such as allowing other family members or friends to call in the hospital to see how you're doing, even though they're not named as an agent on your healthcare directive. Funding documents are also an important part of the estate planning process. So we talked about funding the trust or retitling your assets to the trust being so important. And the funding documents help do that. So you're going to get things like assignment of personal property. That's your things, your stuff to the trust. You'll get a deed transferring your real estate to the trust. And then you'll also get instructions on how to transfer other types of assets that you may own. Things such as bank accounts, checking, savings, regular brokerage accounts need to be transferred to the trust. And also reviewing and updating beneficiary designations on things like retirement accounts and life insurance. Those are all super important. So that will end up being homework for you at the end of the day when you're completed the formal part of creating these documents.
Well, Stefani, I remember going through this process, and it's a process in and of itself to have the conversation with your significant other of what happens to your kids, where do they go, who makes these decisions, who's involved, especially if you have siblings, aunts, uncles. It can get pretty complicated. The thing that I just heard you say is the closing of the loop, and this is how we can help, right, as financial advisors. If I'm overseeing accounts, I have a couple who have a joint investment account that's titled in community property. That's the next best thing. But as soon as you have a trust, we take the certification of trust, those documents, use that to open a trust investment account. So that way, all the instructions of what Stefani just said about what goes into the trust, those people, the power of finance, can access that trust account. And then really great is to go to your bank, right? Your checking or saving institution, open a trust checking. This is really checking the boxes, right? The dotting the I's and the crossing the T's, opening the trust account there, linking it to your trust investment accounts. So that way it's a closed loop. And now you've taken care of all those important financial documents. Stefani, there was one last piece that really shocked me. I think that we're going to look back on this video in, I don't know, maybe even a year from now, 2 years from now, how much social media has changed our landscape of data collection, our private property, our personal information, right? I think that it's not far-fetched to assume that people listening today have at least 5 different social media accounts, right? And my significant other, no one else has my passwords or has access to those things. I don't know if I want to leave those on the different social media platforms forever. I saw this right here in your presentation, social media and electronic records. So you're telling me that through a comprehensive estate plan, you can give instructions towards to these social media companies?
You can give instructions, and really you're giving instructions to your agent on how to manage those and wrap those up after you're gone. And it's unbelievable how time has shifted from just when I started estate planning as an attorney to now, and the amount of litigation and involvement there is over social media and online record keeping. So this has become really prevalent, and it's really important to have it included and addressed in your estate planning documents, because the old way of doing things, which is creating a list of logins and passwords and leaving those in the binder and letting your agents use those, that's super easy and super quick. But unfortunately, when your agent logs in as you under your login and password, technically that's fraud. So you definitely want to give your agents the authority to be able to access your records, to be able to get online banking statements and close down accounts. And also, a lot of social media or email accounts, a lot of providers are starting to incorporate what's called legacy contacts in their own system settings. So part of your planning process could also be to go into your Gmail account or go into Facebook and find that setting, name a legacy contact who will be authorized already by that specific provider to go in, download items that they want to keep, keepsakes, things like that, and then shut down those accounts for you so that the internet lasts forever until you try to take it off. So hopefully they'll be able to take it down for you. And that way you get to rest in peace, and your agents have peace of mind knowing that they've collected any memorable things that are important for them to hold on to.
Stephanie, I'm just laughing aside. I mean, writing down passwords and putting it in a binder. I mean, those passwords, not only, as you mentioned, fraud when you're logging in and someone else's user ID and password, but you don't change and update your passwords, right? I mean, those are not going to be the same passwords several years from now. So that is extremely important.
Very important. Yes.
So Stefani, next, I know that people resonate with stories, right? Hearing stories. And so I know that you have got some great stories, both on the positive and then on the tragedy side. Can you share, let's hear a great story. Let's hear a success story about you implemented comprehensive estate planning for a client and they had a positive outcome.
Yeah, so it's really important when I step in and I'm helping with estate planning and getting things in place, the best success stories are ones that are super boring. right? Everything went well. The estate wrapped up in 4 months. Everyone got what they were supposed to get, and that's it. So this, I've had circumstances where this may not sound positive, but it really is all about making sure your wishes are honored and what you want to happen happens. So I've had instances in which a client comes to me and wants to disinherit one of their children. And that sounds really bad, but life happens, situations happen. And for this client, it was really important to her that the assets go to just 2 of her 3 children. So in that case, we did an estate plan. We made sure all the T's were crossed, all the I's were dotted. And at the end of the day, the child who was disinherited didn't like it, asked for more information, but wasn't able to combat the estate plan, wasn't able to challenge it because everything was done according to Hoyle. And we got everything in place before she became incapacitated, before she passed away. So her wishes were honored. So again, doesn't sound happy, but that's the goal. And that's what I'm here to do, is to help make sure everything you want to happen happens as easy as possible.
Stefani, that had me think about another great example of who needs an estate plan and why. Every family, or not everyone, but certain families have a black sheep in the family, that one disinherited child. What about a child? And this is an experience and a story that I've heard is, either, there are adults who aren't able to work, right? Who have a disability, right? Have an adult disability. And so you can't leave large sums of money to someone who doesn't necessarily take care of themselves, right? And so special needs estate planning, it's probably a whole nother episode that we could talk about. But if your child has severe autism, right, or another disability that really prevents them from working, engaging in society, this is something that I've done where we set up. LPL Financial is my broker dealer. They can set up a corporate trustee, right? So Stefani, you would create the trust. We could add LPL or another financial institution as a corporate trustee. And that way that adult child that you're leaving your inheritance to, whether it's a home or assets or money, and they can take care of that. Is that something that you've had experience with as well, setting those up?
Absolutely. And you're right. It's incredibly important for those circumstances for documents to be in place and people named and ready to go to take over if needed. Because not only do you want to name someone, a professional fiduciary, a corporate trustee, to manage the assets for the individual and help pay expenses and make sure they're taken care of, you want to make sure that their inheritance does not disqualify them from ongoing financial assistance. If they're receiving government benefits and they get this lump sum inheritance in their name, that now they have assets and now they have income from this inheritance, they're going to get disqualified pretty quickly under an asset or an income test. And while the inheritance may be able to provide for them for a certain period of time, it'd be awful for them to go through that and then have to reapply and jump through the hoops to get back on government assistance. So doing your planning, you can also do it in such a way where they still qualify for benefits. They still get their inheritance for everything over and above support already provided. So in that way, they kind of get the best of both worlds.
Right. Stefani, I don't know how only 32% of Americans, like the statistic we mentioned at the top of the show, I don't know how more people don't have a trust. That seems a no-brainer to me. So for those 68 percenters, what are they to do? So we talked about a success story. What is, I don't want to call it a tragedy, but it is, right? If you don't have an estate plan and you're going to court, or even if you have an estate plan and it's out of order or it names the wrong people, if you're going to probate, what is the downside? What's an ugly story that you've seen?
So So it's really unfortunate, but a common one I see is, give an example, client or mom passed away without a plan in place, no trust, no will, survived by one child who is living in the house with mom or needs to move into mom's house for their residence because they just can't afford something on their own. In that case, we have to go into court. We have to go to probate. We have to have the judge sign off on everything. Even the only child getting the house, judge has to sign off. And the real big downside of that is it's expensive. Probate costs are statutory. So it's written by law what it is, and it's a percentage of the estate. And that's a percentage of the gross value, not the net value. So in this example, it's a beautiful San Mateo home that's being inherited. It has a mortgage on it already. So the net value isn't very big, but as you can imagine, San Mateo, the gross value is huge, and you're paying a percentage of that. So I can tell you easy math on a $1 million estate, you're paying $23,000 to the attorney, $23,000 to the executor. And then you pay court costs and court fees, and then you pay your creditors. And the people benefit last are the ones you want to benefit the most, your loved ones. So in this example, child inherits this property, has to pay $23,000 where there is no cash in this estate. The only thing was the house. The only option she had was to go through and refinance the property to pull money out, equity out, to be able to pay attorney's fees, to be able to pay the exorbitant property tax lien that was on the property from mom not paying property taxes for a while. And it was unfortunately a real financial hit that a lot of it could have been avoided, maybe not the property tax lien, but the attorney's fees could have been drastically reduced just by having a trust-based plan.
Just by having a trust. I think that there is definitely, we talked about the stigma that trusts are for the wealthy, right? That's one hurdle, I think, that prevents more people from having estate plans, but also just fear of talking about or confronting or thinking about your own mortality. That has to be another concern that prevents people. So I think we need to end this by having a call to action, Stefani, right? So if you're listening to this, even if you have an estate plan, you've had it for 10 years, that's something we talked about. You need to have that reviewed. Stefani, what should people be doing to either get in touch with you or reaching out to an estate planning attorney to get started thinking about this? What's the call to action?
Yeah, contact someone. If you had a prior attorney that did your estate plan, see if they're available for a review session. If you have no attorney, but you have a financial advisor, check in with them. Check in with Aaron to see if he's got a connection for you, because you also want your financial advisor and your estate planner working together to make sure everything is covered. And you can also reach out to me. I'm happy to have complimentary introductory meetings, just kind of go through what's your family situation like. You can learn a little bit more about me and see if we're a good fit. So contact someone. And if you do want to reach out to me, you can find me on my website, cogginslegal.com. And I'm happy to talk to you.
Excellent. And I'll make sure that folks have a way to reach out to you too. I think that it's very generous that you're offering complimentary consultation. Disclaimer, everybody out there, Stefani is not a part of SGC Financial or LPL Financial. She is her own law firm. In fact, I think we should give a round of applause to Stefani for launching her own law firm. That is just, I'm ecstatic. I'm so excited for you. Folks, you could not be in better hands. I think we'll leave it there, Stefani. The call to action is to, if you got questions, here's your opportunity to have a complimentary consultation with an estate planning attorney. I don't know how else we could deliver value to you. So, Stefani, I really appreciate you taking the time to speak with everyone today. Thanks for being a guest of Exponential Wealth Podcast, and we will talk to you soon.
Thank you so much, Aaron.
All right, bye-bye. Today's guest, Stefani Coggins, estate planning attorney at Coggins Legal, is not affiliated with SGC Financial nor LPL Financial. The strategies that we discussed today around establishing an estate plan to protect you and your family are best implemented when working in conjunction with your financial professional and an estate planning attorney to legally prepare that document for you. Please work with a professional to best determine what is best suited for you when implementing these strategies. Catch everyone on the next episode.